Alright guys, today we are going to discuss the topic of constitutional doctrines of EU law. Before we begin, I'd like you all to take into account that this topic is a highly examinable area which comes almost every year in the EU paper. So I reckon that you study and prepare this area for your final examination. There are two fundamental doctrines that we will be discussing under this topic, namely direct effect and supremacy of EU law. Now, what is direct effect and what is the concept of supremacy? Before we jump into these terms, we must understand that similar to how a sovereign state operates, the European Union too has its own organs, namely the European Commission, which proposes new laws. And then we have the European Parliament, where lawmakers get together and vote on new laws. And finally, the European Court of Justice, which interprets laws. The CJEU, also known as the Court of Justice of the European Union, established and obtained acceptance of these two vital principles of direct effect and supremacy, which helps the previously mentioned organs function without any issue. Now, what is direct effect? This was enshrined in the landmark case of Van Gent en Loos, specifically in paragraphs 9 and 13 of its judgment, which stated that it is the possibility for individuals to invoke a provision of EU law before a national court. As we can see, this refers to the capacity of a norm of union law to be applied in domestic court proceedings.